Good morning, everyone. This proceeding is being live streamed on YouTube consistent with the open courts provision of the Texas Constitution. If any of the parties have an objection to the live stream, kindly bring up your objection to Judge Iserlo when she calls your case. With that being said, the 455th District Court is now in session. The Honorable Judge Iserlo presiding.
All right, good morning, everyone. It's Judge Iserlo here. I call case number D-1-FM-22-000946. We're hearing a petition for writ of habeas corpus. I did bring us into a Zoom hearing with the hopes that maybe we could come to some agreement without having to bring this 4-year-old child into court. If we can't, then we will do that, but it does seem hard on the child. So, Mr. Frazier, I believe this is your motion. Please proceed.
Yes, Your Honor, that's correct.
Be very, very specific on what you're looking for and what the concern is, okay?
Sure, absolutely, Your Honor. That we've got a child before the court, as the court acknowledged, a 4-year-old Inca. She's the only child of the parties and the subject of the pending suit affecting the parent-child relationship in Travis County. There are operative orders in place, those being temporary orders from a hearing on April 4th of 2022. That was a Zoom hearing in front of Associate Judge Arth. The parties went back and forth with some draft versions of those temporary orders. We ultimately had to have a motion to enter hearing in front of Judge Arth. The judge signed the operative temporary orders on that date. And so, of course, what we're here for, Judge, are the 4 corners of the controlling document. We believe there's a valid subsisting order governing possession and access of the child. My client is entitled to present possession of the child, and therefore respondent is illegally restraining the child. The question really seems to be about extended summer possession. And what is unique about these orders, these temporary orders, again, considering how young the child was at the time they were rendered, they do not afford Mr. Bloomling any extended summer possession. He has something called a temporary possession order. That term is used on page 6, and there's various different phases that Mr. Bloomling has graduated to.
I saw those 3 phases in there, yeah.
And he's currently under phase 3 because that began on August 15th of 2022. And that starts on page 7 of the temporary orders. And though he is awarded the terminology of expanded standard possession order is utilized, it's my belief that Mr. Bloomling is interpreting that gives him 30 days in the summer. But again, in the 4 corners of the document, he is not awarded any extended summer possession. And for the court's knowledge, even at the motion to enter hearing, there's not a transcript, unfortunately, from the hearing, but it was Mr. Bloomling, then represented by counsel's position, that 30 days should have been added. And so there were drafts that were done, and Judge Arth heard the argument of counsel and rendered explicitly in the operative temporary orders that he was not to have extended summer possession. If the court wants to indulge, there's many communications that led up to this weekend informing Mr. Bloomling that he did not have extended summer possession in somewhat sarcastic.
No, we don't need to get into the middle of all that. Here's our situation, Mr. Blooming. I have looked at this document. Let me hear from you. What's your situation? Why are we here today? Because I'm trying to do this as painlessly as possible right now, but it's going to, the pain meter is going to go up as we continue down this road this week. So let's talk about, I'm bringing you all in here today because you've got a 4-year-old child, and that child's best interest is always what directs me. Yes, so I don't really think it's in his best interest for me to have him come here on Wednesday, or on the alternative, to have a deputy come get him on Thursday. So where are we with this, Mr. Blooming?
Your Honor, the orders do clearly state that unless explicitly stated otherwise, I am to follow the extended standard possession order. I don't need to tell you the extended standard possession order. I get the non-custodial parent gets the child in the month of July. I notified Ms. Hudnall on March 30th of my intentions. She has repeatedly restricted to me, and I have this all very well documented, that she will not let me see the child for a minute longer than she is legally entitled to do so. I'm a teacher. I have the summers off. She is keeping our child from me at every opportunity that she gets. The document clearly states, unless explicitly stated otherwise, there is nothing in this document, regardless of how poorly it is written, that states anything about the summer. Because there's nothing explicitly stating the summer possession, then I am entitled to the ESPO. And the last thing that I'll say about this is that when this was written, the phase 2 going into last summer would have been July, which is why there was no expanded standard possession order then. And I completely understand that. I have offered Ms. Hudnall a very generous schedule for the month of July so that we can go visit our daughter's grandparents in Florida. She has repeatedly kept our daughter from me at every turn. I get no updates. I get no photos. I do not get invited to dance recitals. It is not in the best child's interest. Ms. Hudnall is working in her best interest.
Okay.
I will pre-K.
All right, I hear you. I hear you. Okay, Mr. Frazier, tell me where we are with this. What's the specific phrase in this document that makes you believe that your client's entitled to have this child back this summer?
Sure, Judge, that Mr. Bloomling has specific periods of possession, the first, third, and fifth weekends of the month during the school term. There's no extended summer possession. And on the bottom of page 9, top of page 10, there's possession, the language says possession by Jessica Hudnall, my client. And it says Jessica Lee Hudnall shall have the right of possession of the child at all other times, not specifically designated in this possession order for Corey F. Bloomling. Mr. Bloomling is citing via this reference to the expanded standard possession order and online research extended summer possession that is not contained in the four corners of this document.
I'm sorry, I completely disagree. It says it in the very beginning of phase 3, preceding what you're citing. It says, unless explicitly stated otherwise, I am entitled to the extended possession. Your Honor, I will gladly do what you believe is in the best interest of our child. I have a very hard time believing that restricting access to both parents to a 4-year-old is in the best interest of the child. She deserves to have a healthy bond between both parents. I have followed the temporary orders to a T. I am up to date on child support plus arrearages that Ms. Hudnall is taking from me. This is not in the best interest of our daughter.
Okay. All right. So here's the situation. I'm not here to make a best interest finding today. The only thing I'm trying to do is follow the order as it's written, and the order indicates that she gets your child to be with her today. So here's the only thing I can do at this point, y'all. And it's not, I know, Mr. Blooming, I hear you, and I hear the frustration in your voice, and I hear that you do care very deeply for your child. The only thing is that I'm just looking at the order as it's written, not kind of attacking the order outside of its four corners. So the child does need to go to your wife today. Now, if that cannot be accomplished,
we were not married.
Then we got to come back on Wednesday and with your child here in court. And if he's not here on Wednesday, we got to send the deputy on Thursday. This is a 4-year-old child. So I think we need to go on and put our differences aside right now and comply with the four corners of that document, even if we don't agree with it. Okay, Mr. Blooming, can you do that?
Just so I hear you correctly, the explicit standard possession order does not apply to this situation.
Listen, you just have to follow the four corners of that document and look at it. There's the bottom of page 9 is where it's instructive. So here's what you
that's not in phase 3. We're in phase 3.
Okay, here's what you can do if you're not happy with it. And I've read the order. I do think that it appears to me from the plain language of that order that your wife has a child today. You can, if you want to attack some of that order, when you set up your final hearing, that would be your chance to have your attorney look at that. But today is not the day for that. I just have to go what's in that four corners of that document. And I have looked at it. And I do believe that Ms. Hudnall is correct in this. So, all right, so here's what I'm going to suggest, Mr. Frazier, Mr. Blooming, Ms. Hudnall. The child does need to go back to mom today. If that does not occur, then we need to set a hearing on Wednesday, and the child will need to come to the courthouse. If that does not occur, then we're going to have the deputies come out and pick up the child on Thursday. But right now, that's where we are right now. And
I'll drive her over to her house right now, Your Honor.
All right, very good. Thank you for that, sir. I appreciate that very much. That's obviously, it's critical that that occur, and it shows your care and concern for the child that you are willing to do that. And I'm very, very grateful for you doing that. All right, you all, I know this is not a terrific situation we find ourselves on this July 3rd, but it's the best we can do right now. When you do have your final hearing on this, there'll be an opportunity, I think, to question some of that order. But right now, we have to go with what's written. All right, Mr. Blooming, please get the child over there right now. Okay.
And my client's at my office, so she'll leave immediately. So should we say noon? Does that sound okay, Ms. Hudnall? Can you confirm? Is that okay?
It's 11:15. Yes, noon.
Does that
Your Honor, if there's going to be just a
Uh-huh.
little bit of a lag time, my daughter and I made cupcakes this morning and we haven't put the icing on. So can we make it 12:15, 12:30, and then I can send her back with icing on her cupcakes?
Yes, Your Honor, that'll be fine.
Thank
All
you
right,
very
let's do that. Okay, with
12:13.
cupcakes and icing at 12:30. Okay,
12:30, Judge. And do you need, I'd like to probably have an order, or do you think an order needs to be circulated, Your Honor, for the file?
I think it probably does for the file.
Yes. I
But
can draft and send a copy to Mr. Bloomling for his review, and if we need some kind of entry hearing, which I'm sure won't be necessary, we could get with your court.
that sounds fine. Ms. Hudnall? All right, very good.
think
All
that's-
right, Mr. Frazier, Mr. Blooming, Ms. Hudnall. All right, I expect the
Oh, I'm
child,
sorry. Last second. I just want to make it clear. I am dropping our child off at Miss Hudnall's residence. Is that correct?
My
that's
understanding
correct,
at
at
12:30.
12 by
12:30.
12:30 today. So that gives you a little over
Hour
an
50.
hour to get there. Okay,
Thank you very
Thank
much.
you, Judge. Thank
All
you
right.
so much.
you all have a great rest of the day.
Thank
Happy
you, Your
New
Honor.
Year.
Good luck with everything.